British era law designed to crush and silence any kind of dissent against the then British government and the empire ruling our country. That law, over 162 years old law, was still active, is still being used in our country, even after 75 years of independence. Successive governments across states of our country have used this law against those who they have seen as a threat, not necessarily to the nation or the establishment, but to those in power. In a democratic country, I have always believed the sedition law is problematic. I have always believed that such an archaic, draconian law has no place in a democratic country, a law that empowers the establishment to chase those who are asking questions, from journalists to activists. Today is a historic day in a sense, because the Supreme Court has nudged the government to reconsider this law and put the law on hold. The sedition law that exists in our country has been put on hold. Today we're going to discuss this. We're going to discuss all about what's transpired in the courtroom. We're going to talk about what the central government stand has been on sedition all this while. We will tell you what it means for those who are still in jail facing charges of sedition. We will tell you what happens next. What is the Indian government planning to do? We'll tell you about how widespread the uses of this sedition law, and why is it that this 162-year-old law is considered outdated and something that must go. Joining me right now is our in-house expert at Boom, Ritika Jain, who covers all things legal for us and has been very closely tracking this case in the court as well. Ritika, first, let's start with what happened in the courtroom today.
So today has been crazy. The Supreme Court has been dealing with the sedition cases for a long time, but it was only last year in February when it issued notice on a plea seeking to scrap sedition altogether. So today, a year after it issued notice, the Supreme Court has put in abeyance section 124A of the Indian Penal Code, which is the law pertaining to sedition. Now, what is abeyance? It simply means hitting the pause button or putting the law on hold. The court had observed that while the centre is reconsidering and re-examining this law, it would be inappropriate to use it. And the Chief Justice N.V. Ramana also pointed out that even the centre agreed that this colonial era law is out of place in the present situation. And in fact, during the last few hearings, even the Attorney General K.K. Venugopal has highlighted instances of misuse of the sedition law. So I think all of this has accumulated and come together to basically help the Supreme Court give its decision today.
Okay, Ritika, what is interesting is you mentioned what Mr. Venugopal told the court. You also mentioned what Centre's last, proposal or submission in the court was. Let's go into the details of that, because it's extremely important to understand where the government is coming from. What has been the government's, view, say a few weeks ago to now, and the latest stand in the Supreme Court?
Okay, so like I said, that notice was issued last year in February, but the hearings have actually just kicked off in the past few months, where the Supreme Court really said, okay, just come back with an answer and let's take a decision on this once and for all, because there are a lot of cases in the lower courts and the high courts where there are bail matters on sedition issues which are also pending. And the High Court, in fact, in Umar Khalid's hearing said that till the Supreme Court doesn't decide, how can we take a decision, So I think it all came back to the Supreme Court finally saying, let's deal with this once and for all. So while the hearing was going on, now there is this judgment called the Kedarnath Singh judgment. It was passed by the Supreme Court in 1962. So that in itself is also quite old now. It's more than 60 years old. So the Kedarnath judgment simply said that it basically upheld the validity of sedition as a law, but it kind of narrowed the parameter. It said that only speech that incites violence directly is seditious. Anything else is exempt. And this observation was also upheld in the Vinod Dua case. Now, Vinod Dua case was in June 2021, where the Supreme Court quashed all charges against him because, after all the cases against him. Now, cut to right now, the Supreme Court said that to decide on sedition also, first we need to relook at Kedarnath. So they would first need to look at Kedarnath to see whether the Kedarnath judgment, which was also incidentally upheld by the 5-judge bench, was it right or did it also need to be relooked? So if that had to happen, then the Kedarnath would first have to be decided by a 7-judge or a higher bench, and then they would then come back to sedition, which sounds like a long process, and it is kind of a long process. So it was during all of this on Saturday. Solicitor General Tushar Mehta's office filed submission saying that the Kedarnath judgment was good law and that individual cases of abuse or misuse of this law was no reason to rework or rethink the entire judgment altogether. Then 2 days later, on Monday, which is day before yesterday, the centre filed a separate and fresh affidavit saying that it was reconsidering and re-examining the law on sedition because this was in spirit of the 75th year of independence and Azadi Ka Amrit Mahotsav, and it was also the Prime Minister's vision that you uphold civil liberties, and it was time to shed the colonial baggage. So in all of this now, the latest stand of the government is that it is relooking at sedition as a law. The process, Tushar Mehta told court, has already begun. And as for a timeline, there isn't a definitive timeline because he said these are matters of importance and it needed a vibrant discussion from all stakeholders. Now, that happened on Monday. Then Tuesday, the Supreme Court was like, okay, so if you are reconsidering the law on sedition, then what happens to pending cases and what happens to cases that may come in future? We need an action plan. Which is when the centre then came up today and said that we cannot really put sedition in abeyance, but it had suggested and proposed a few guidelines wherein it said that, we can follow guidelines on sedition expeditiously or scrupulously, and we can have extra layers of scrutiny, and if at all that there were sedition cases, then the courts could look at the matter when it came at the bail stage, on time. So all these events have happened, and then we're to today.
Okay, so Ritika, while you recap for us what's been happening in court when it comes to sedition and the government's official stand in the Supreme Court, which is essentially being the government first said that yes, now we are willing to re-examine the laws on sedition, but suspending or putting in abeyance the current law may not be the right approach. The Supreme Court, of course, has urged the government to do the same. Now, the centre instead said we will give guidelines to how file the FIR. We will follow this Kedarnath judgment, use that order really to make their case, or rather Tushar Mehta said so. But let's also see politically what has been the case when it comes to the current government. In 2020, there was a written response in the parliament that was given on sedition, because this has been a big debate now for a long time, where the centre said that public order and police are state subjects, that states are responsible for law and order, and they are responsible for registration and prosecution of cases. So at that time, centre didn't want to really take a stand on this. They kind of passed the buck to the state governments to say, well, law and order is a state subject, and they're the ones who are actually using this law as well. So imagine saying that.
I'm sorry to interrupt it. The centre did that yesterday and today as well. They said that the executive and the legislature can look at the law, but actually law and order is a state subject. So if any sedition cases are to be filed, it's actually the prerogative of the state, the police of the state, and it's the state government that decides that. It's got nothing to do with the centre.
Yes, and this is a very important point that I wanted to highlight because this has been, centre's view in parliament, in the court as well, and essentially, yes, because law and order comes under the state government. Even though today the Supreme Court has said what it did, it will be incumbent on the state governments to ensure that they do not use this law anymore until further clarity really comes in. Now, Ritika, let's also talk about what happens to the existing cases, right? Because sedition law is so strict and so stringent that it becomes extremely difficult for people who've been jailed under sedition charge to even get bail. And there are hundreds of cases like that currently in our country. What happens in those cases? Do we have any kind of indication?
So the Supreme Court has said that there will be no new registration of FIRs under sedition from this point on. Investigation in all pending cases have also been put on hold. And when it comes to people who are now in jail, I think this is my gathering understanding of what happened in court today, that they can now probably go to court and high courts and say, look, this law is on hold. Look, the center is also relooking. So give us bail because we don't know how long that will take. So they can probably now file for bail, taking the Supreme Court's orders from today. But let me also clarify that it's not necessary that they may be free too. Now, if you take Umar Khalid or Sharjeel Imam, for example, they have been charged with sedition, but they have also been charged with various other offences on the same FIR. So even if they do get bail in sedition, if they don't get bail on other offences, then they're not coming out. So this is just a point that I wanted to clarify. While it will help them, of course, but then at the end of the day, the high courts or any court, they look at the whole FIR comprehensively, they look at all the charges comprehensively before giving bail.
Yes, so what Ritika is telling us here is that this doesn't mean automatically everybody who's in jail or facing a charge in a case of sedition will have nothing to worry about anymore, because there are several more charges that they may be facing, equally stringent if not more, and those cases will have to continue. But if you are facing a case and a charge of sedition, you do have the option now to go back to your court and tell them that, well, you know what, this is what the Supreme Court has now said and done. Please reconsider my case and see if you can give me bail. That's what essentially one could expect. Now, meanwhile, because it's on hold, the central government is going to re-examine the law itself, which doesn't mean necessarily that the law is going to go away. They may just tweak it. They may clarify and make it harder for governments and law enforcement agencies to use this law itself. They may say that you will have to really prove your case as to why you want to use sedition. So we don't know how it will really pan out in the next few months, but the government has been given time for a few months to work on it, and then we will have to see what happens in the court. But
there is no, hang on that, there is no definitive timeline, nor has the Supreme Court imposed a time limit. I've just wanted to clarify that. The next hearing has been scheduled for the 3rd week of July. So we can probably expect a status update, or of course, if the government has something more substantial to say, they will. But we will know what will happen next in the 3rd week of July now.
So it could actually be 3 months, 2 months, or even 3 years, or maybe longer. We don't know how long it may take, right? So that's good to put it out there for our viewers as well. Now, let's get to the part of usage. And we were speaking about this earlier, Ritika, that the states are essentially the ones who use this law. What does the recent data tell us? How widespread is the use of this law? Obviously, it's not limited to 1 or 2 party governed states. It's essentially pretty much across the country.
Yeah. So first, let me also clarify that after today's order, the Supreme Court has asked the center and the states from not filing any more cases. The center has also been told to issue directives based on the order today. So that is point number 1, which needs to be done. The center will have to do that, issue of communication to all states on the update of what happened in the Supreme Court today. As for the number of sedition cases today, Kapil Sibal just let slip that there are at least 13,000 people in jail in 800 cases on sedition alone. We will need to verify that, but I have this story on sedition that we had done last year. It was based on NCRB data, the National Crime Records Bureau, which basically keeps check on all the FIRs filed and the kind of cases that have been filed. So under NCRB, sedition comes under offences against state, which is quite a wide subhead, which also includes UAPA amongst others. But if we look at the NCRB data, I think in 2020 there was Manipur, the state of Manipur had the sharpest increase in the number of cases that were filed, sedition cases that were filed. followed by, if you look at the data again, I'm sorry, I'm just pulling it up.
Just pull out the data. Meanwhile, let me just give our viewers a larger picture while Ritika pulls out the state-wise breakup for us. There were 93 cases in 2019. So in 2019, we actually saw a large number of cases being filed, and viewers will remember that in 2019 and 2020, we've actually seen a series of protests in various parts of the country as well against the governments. 44 people were actually arrested under sedition in just 2020. If you see the time period between 2015 and 2020, 356 cases of sedition were filed just in this time period. And while the conviction rate in 2020 was abnormally high, which is still 33%, not in isolation very high, but if you look at the past record, this is still considered much better, because in 2019 the conviction rate was 3.33%. Before that also it was largely below 20% kind of a conviction rate that we saw. And in fact, till a few years ago, we were not even getting a collated data of sedition cases in our country. It wasn't put together with all the states and centrally put out on the public platform. It's only now in the last few years that we've started to do that. Ritika, like you were pointing out, in 2020, maximum fresh cases were actually filed in Manipur.
Yes. Also, if you look at, so NCRB data is always of data the year before. So even if you're sitting in 2022, we don't yet have data from 2021. I think we're going by 2020 yet. So as per that, if you look at it, between 2016 and 2019, the number of sedition cases rose by 160%. And even as the conviction rate dropped to only 3.3. Now, I have spoken to many experts while, talking about sedition, while writing our stories for Boom. And they have said that primarily these cases are filed as a harassment tactic. Again, this is not my opinion. This is what the experts have told me while I have discussed these figures with them. BJP rule states, in fact, like Karnataka, Uttar Pradesh, amongst others, they had the maximum number of cases amongst all. Again, this is something that the NCRB says. In fact, looking at this data, even in May 2021, Justice Chandrachud had observed that the law like sedition has no place in modern democracy, and it was time to define the limits of sedition. After him in July, even Chief Justice Ramana had said, do we really need sedition in a modern democracy like ours? So there have been concerns. The Supreme Court has observed the potential of misuse, has observed that there has perhaps been misuse, and that's when they said, okay, now let's just figure this out, and let's get this, let's decide this one way or another.
Yes, in fact, you quoted, two very important commentary that came in from the Chief Justice of India and Justice Chandrachud both. And repeatedly, in fact, courts have given enough and more hints directly and indirectly to the government to say, well, the use of sedition law is really not the right way to go. For example, like Ritika was pointing out, Justice Chandrachud said that criminal law, including anti-terror legislation, should not be misused for quelling dissent or for harassment. This was last summer. Chief Justice of India then came out and said that sedition law is a colonial law which was used against freedom fighters, and misuse of law, no accountability by authorities, conviction rate linked to this is very low. So all the problems that we are telling you right now that exist with this law have also been at some or the other point mentioned by the sitting judges of the Supreme Court and even the past judges. It's only now finally that the government, the executive of our country, is actually admitting that, okay, they are willing to now re-examine this law. Thank you, Ritika, so much for joining us and really putting this in perspective for our viewers. I'm going to let Ritika go at this point. She has another big case to track in the Supreme Court, a case on marital rape law, where again it will be very interesting to see what the government stand will be and if there is any change in that. So I'm going to let Ritika go at this point.
I'll just take the moment to say Delhi High Court actually within half an hour will tell us whether it has scrapped the exception 2 to rape laws, whether it has criminalized rape, marital rape or not. So that is the next big thing today. and that's from the Delhi High Court, which is also going to be an
So it's going to be a very, very big case. And Ritika is going to be with us, getting us all of those updates. Thanks so much, Ritika, for joining us. Quick recap for our viewers who may have tuned in a little late. The Supreme Court has put the sedition law on hold, in abeyance, as it is said in legal terms. This means that the Supreme Court has also urged the governments to not file FIRs under the existing sedition law until the law itself is examined. For those who are in jail under section 124A of the Indian Penal Code, they can seek bail, not necessary, they will get it. In case, even after Supreme Court's commentary, in case there are still any fresh cases filed by any police in any state, then the accused can seek relief from the court. This is important because sedition law is so draconian that bail usually doesn't come easily in such cases. And the center can ask the states to prevent the misuse of section 124A. The biggest issue with this law has been the misuse of this law, not just by one government, not just by one state, but over the years by successive governments across the country. So this is just the beginning. A lot more will happen when it comes to the sedition law, and when it does, we will be back with more. Thank you so much for joining us on this edition of Simplified.